Hey there, this is Tanya Marsh. I'm a professor of law at Wake Forest University in Winston-Salem, North Carolina. And there have been a lot of questions coming up lately in the various Facebook groups about copyright law and what that means for people who are trying to create free stickers to give out at shows and other kinds of sort of Avett-inspired artwork and swag. So I've been asked if I could talk a little bit about Copyright Law 101 and how it would impact some of these questions. I teach property law at Wake, and copyright law is talking about intellectual property. So this is kind of what I do. So I'll try not to make this sound too much like a law school lecture, but you're going to have to forgive me because we got to go through some of the boring stuff at the beginning. There's a couple different kinds of intellectual property. This is the non-tangible property you can't touch. It's protected by the law in various ways in the United States. We're going to be talking about copyright law today because most of the material, all the material really that people are interested in using for Avett stickers and swag are protected by copyright law, and that's art, music, and literature. Inventions are going to be protected by patent law. Business or product names, for example, the name, the Avett Brothers itself, that's protected by trademark law. Business secrets are going to be protected by trade secret law. Intellectual property is pretty important in the American property system, in the American legal system. It's even mentioned in the U.S. Constitution. Article 1, Section 8, Clause 8 is the Patent and Copyright Clause. It grants Congress the power to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive right of their respective writings and discoveries. So this is talking about the limited times that we're granting exclusive rights to authors, that's copyright law. The limited time we're granting exclusive rights to inventors, that's patent law. Congress has exercised its authority under Article 1, Section 8, Clause 8 of the Constitution at various times throughout history. The current law that applies is the U.S. Copyright Act, which is found in Title 17 of the United States Code. If you would like more detailed information than I am providing for you in this video, here is a link at copyright.gov / Title 17 where you can read the full text of the U.S. Copyright Act. So here's the most important thing to begin with. What is it the U.S. Copyright Act actually protects? It protects original creative work that's fixed in a tangible medium of expression. It's these first two elements that are most important. It protects original work, that is work that's independently created by the author. Okay, so, author meaning somebody else other than you, right? Creative work. Copyright law doesn't protect facts, no matter how hard the author worked to discover them. This is sort of sad for me as an academic because most of the stuff that I write is about the law, right? So I'm writing about facts. Sometimes I work really hard to figure out these facts, but it doesn't matter. That's not creative expression. That's not creative work. It's not going to be protected by copyright law. Other people can take my books and my articles and then, derive from them the facts and write up their own stuff. That may be plagiarism, but it's not going to be a violation of copyright law. The idea of work in terms of what qualifies for copyright protection is super broad. Okay, so I mentioned before art, music, literature as really broad categories. Well, photography, lyrics, musical compositions, whether or not they've been reduced to sheet music, drawings, sketches, paintings, sculpture, choreography moves, software code, recorded musical performances, whether they were live or in studio, plays, movies, streaming video, everything. It's all work. If it's original and creative, it's going to be work, okay? Fixed and tangible medium of expression. Really, the courts have said almost anything is going to count as fixed and tangible medium of expression. So really, for our purposes, all you need to worry about in terms of what is protected by copyright is that we're looking at original creative work, and it is super duper broad. Okay? So what do authors need to do to protect their work under copyright law? Well, some folks are confused and think that the authors of original creative work need to do something affirmative in order to have their work protected. That's because under prior law, that was true. You had to register with the Copyright Office to receive protection. But under current law, authors have to do nothing. So as a baseline, if it's someone else's original creative work, number one, it is protected by copyright law. Number two, it's protected by copyright law. They don't have to do anything. It's automatically protected by copyright. Now, the author could affirmatively place it in the public domain, for example, through a Creative Commons license, which may permit other people to use it for any purpose or only for nonprofit purposes or educational purposes. There's different kinds of Creative Commons licenses. And some of the folks in the Avett fan community who take photographs have affirmatively placed their photographs under a Creative Commons license and made them available for everyone. But it is a true statement that none of the work created by the band is under a Creative Commons license. It's all protected by copyright law. How long does copyright protection last? Well, here's all the rules. Basically, let me summarize them. A long time, and for all the kind of work that we're talking about, it is all clearly protected by copyright law. What rights does the owner of a copyright have? Okay, important things to note about the rights that the owner of a copyright has. Number one, these are exclusive rights. And when I say these are exclusive rights, it means if they own these rights, you don't own these rights, even if you bought a copy of their work, right? If they own these rights, you don't have these rights. They have the right to reproduce it. They can make copies of a protected work. You can't. I think we all learned long ago, hopefully, that we cannot just copy, burn CDs and give them away. That's pirating music, right? FBI warnings on the front of movies, right? That's just pirating. But it's not just music and movies we can't reproduce. It's also the images. It's the artwork on the cover of the vinyl or whatever, right? That's their right to reproduce, not our right to reproduce, even if we bought a copy of it and it's sitting in our living room. Related to that's the right to distribute. They have the right to sell or otherwise distribute copies to the public. We don't. They have the right to create adaptations, that is derivative works, the right to create new works based on a protected work. And they have the right to perform and display. And the copyright owner can sell or license any of these rights in whole or in part. A license is just a fancy legal word for permission. They could sell that to you or they could give that to you for free. They could grant you permission to use their work in whole or in part if they wanted to. Enforcing copyright. So I said you don't have to go to the U.S. Copyright Office and register your work in order to have the copyright in the first place, but if an author feels like their copyright's been infringed on and they want to file a lawsuit, they do have to go register their copyright with the U.S. Copyright Office as a predicate to filing the lawsuit. If a court finds, after a lawsuit's been filed, that a person has violated copyright, then the owner can get an order from the court stopping the person who'd been doing the copyright violations, preventing further violations. They could, the owner of the copyright could get awarded money and sometimes, depending on the facts, attorney's fees. The person who used the copyrighted protected work has a couple of potential defenses. There's a couple that apply more broadly to many sorts of civil lawsuits that I didn't include in this list, but the two of them that are most relevant to copyright violations are it was authorized under a license, again, that was either sold or given for free, or it was allowed under the Fair Use Doctrine. Fair use is going to be pretty relevant to what most sort of creators are thinking about here. There is also, I have found from reading comments and Facebook posts, substantial and widespread misunderstanding of what the Fair Use Doctrine says. It is way more complicated than many folks are giving it credit, and it is also not as clear and objective as many folks appear to believe it is. So I want to spend some time walking through fair use and then applying the elements to a couple of common scenarios. Okay, the basic idea of the Fair Use Doctrine as a defense to a copyright violation. Remember, we've got copyright, you've infringed upon copyright, and now you're claiming a defense to that infringement, and that defense is fair use. The basic idea is that the public should have the right to freely use portions of copyrighted work for the purposes of commentary and criticism. The idea is that copyright law, copyright protection is at odds with the First Amendment, right? And so we can't use copyright as a tool against First Amendment free expression. We still have that, and that is the first of the amendments, right? It is arguably the most important and most vital to a free society. But First Amendment it's not trying to protect commercial use, right? It's about commentary, criticism, really political speech, right, at the heart of it, etc. Okay, so fair use is a potential defense to a claim of copyright violation. It's not a free pass to use copyrighted work. Not a free pass to use copyrighted work. And copyright law sets forth a series of factors that will be considered and weighed by the courts when they're considering whether or not fair use is a valid defense in a particular case. But weighing fair use factors is subjective and can be pretty tricky. So there is no magical formula. There's no checklist that we can go down and say, yep, what you're doing is fair use, or nope, what you're doing isn't fair use. The best that any of us can do is say, well, these factors are weighing in favor, these factors are weighing against. You're just going to have to make a risk assessment and decide what you want to do. I'm going to try and offer some more guidance as we go through, and especially at the end of the video. Okay, so here are the 4 fair use factors. Number 1, the purpose and character of your use of the copyrighted work. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion taken. And 4th, the effect of the use upon the potential market. Factor 1, the purpose and character of your use. Has the copyrighted material been used to help create something new, or are you merely copying it? Has the copyrighted material been transformed by adding new expression or meaning? Was value added to the original by creating new information, new aesthetics, new insights, and understanding? You can see how these questions all relate to the purpose of fair use, right? Which is to allow portions of copyrighted work to be reproduced in order to promote criticism and commentary. Well, here's a hopefully helpful table of some of these conditions. Are you using it for teaching, for research, for scholarship, for criticism? I'm an academic. If I want to use somebody's copyrighted work in a classroom, if I want to incorporate it into this video because I'm trying to teach you about copyright law, then that's going to be very favored for fair use. As opposed to, look on the other side of the table, is it just for entertainment value? If it's just for entertainment value, then the courts aren't going to favor that as much. News reporting, that's very First Amendment. Transformative or productive use, right? Changing the work for a new utility. The more you transform the work, this is a theme that I'll mention several times, the more you transform the original copyrighted work, the more you incorporate it with your own creative work, the more likely it is that fair use will be a valid defense. Who are you distributing it to? What's the character and purpose of your use? Are you just giving it to the students in your classroom? Are you just giving it to a small group of friends? Are you using it for personal use? Or are you widely distributing it? The more restricted the access to the end product that you're creating, the more likely it is to be fair use. Now, note the first 2 items under conditions undermining fair use. Commercial activity is different from profiting from the use. Commercial activity involves the exchange of consideration for the material, the new material that you're making. Yeah, these stickers are free, but send me some money to help offset the cost of making them and I'll send you one. That's commercial activity. Even if you don't call it a sale, even if you're making no profit because you're breaking even or losing money on the whole transaction, that's still commercial activity. Now, more problematic potentially is, show me that you gave $5 to Press On Fund or St. Jude's and I'll send you a sticker. I don't feel great about that. I don't know if that would be commercial activity or not. I think that it is arguable either way because someone is receiving consideration. Because again, commercial activity is a different line item consideration than profiting from the use. Something can be commercial even if you're not profiting from it. Denying credit to the original author I don't think is relevant in any of this sort of Avett World stuff because we all know who created all of these things we're using. Factor 2, nature of the copyrighted work. Again, this first set of factors, published versus unpublished, is not relevant. Everything we're dealing with here is published. Even a song that's never been on an album, if it's been performed in public, it's been published for purposes of copyright protection. We also don't need to worry about the other factors. The published work falls in favor of fair use, but man, this is as highly creative of work as one can get. We're not talking about factual or nonfiction. We're not talking about our use being important to educational objectives. We're talking about highly creative work, art, music, right? And that is going to undermine fair use, that we're using someone else's highly creative work. Factor 3, the amount and substantiality of the portion taken. I think this is a factor that can really make a big difference in whether or not the things that we're creating would be viewed as being fair use. If you're taking a small quantity as opposed to the whole thing, it is much more likely that you're going to be protected by fair use. If I just use a phrase from a song or an element from a piece of art as opposed to reproducing a poster that an artist made or reproducing an album cover, etc. Now, the portion used is not central or significant to the entire work versus the portion used is central to or the heart of the work. That's a little bit more problematic when we're talking about lyrics, because if we just take one line from a song, decide what to be and go be it, say love, no hard feelings, right? We all know what song those lyrics are from, and those are central to or the heart of the work. That's the whole point. That's the whole reason we'd be using that line. But that factor is not going to be, in this context with lyrics and with a single line, etc., that factor is not going to be as significant as the portion of the material that you're using, a small quantity versus a large portion. Factor 4, the effective use on the potential market. Are we going to replace the sales of the copyrighted work, or we're going to impair a potential market for the copyrighted work or derivative works? Now, we all know, of course, we can't pirate CDs, right? We already talked about that. That could be replacing the sale of copyrighted work. Significantly, it could be significantly impairing the market or the potential market for the copyrighted work. But what if I take an album cover or a poster and reproduce it on stickers and then sell them or give them away for free? Does it matter if I sell them or if I give them away for free? Does it matter if the owner of the copyright is selling stickers right now? That would speak to whether or not I'm replacing sale of the copyrighted work, but it's a whole nother item about whether I'm impairing a potential market for a copyrighted work or a derivative work, right? Just because the artist isn't selling reproductions of an image that they created in different mediums right now doesn't mean they don't have the right to. They absolutely, as copyright owner, have the right to. We don't have that right. And if a court finds that we are infringing upon their potential market, even if we're giving it away for free, that's going to significantly undermine fair use, right? Okay, so back to the first question, what's protected by copyright? Are these things protected by copyright? We have the emotionalism cover, a cat lamp poster, part of the lyrics from No Hard Feelings, a Scott Avett print, and then in the bottom left-hand corner, a photograph that I took at Red Rocks, and then the guy signed it. Are these protected by copyright? Yes, they are all protected by copyright. They are all original, creative works fixed in a tangible medium of expression. Okay, so let's apply copyright law to a couple of examples. So let's say, here's the Emotionalism album. I bought a copy of it. I did. I have the vinyl sitting right over there. Let's say I take a photograph of it, right? I didn't just download the image off the internet, which obviously I did here. But let's say I take a photograph of it, of the piece that I own, and I want to make 100 copies of a sticker to give away free at shows. And then let's also consider, what if I want to make a cross stitch and sell it on Etsy? Let's look at the sticker first. So I went back through all those different factors that we looked at, and the only condition favoring fair use I could come up with is that the Emotionalism logo is a published work. That's it. Now, I mean, fair use is going to be, to some extent, subjective. It's not a bright line sort of a test. That being said, I was trying to be generous. Only condition favoring fair use I could come up with is it's published. Conditions undermining fair use, it's for entertainment value, right? It's to be nice and build community, but that's not a factor under the Fair Use Doctrine, right? Criticism, commentary, scholarship, teaching, those are factors under fair use. Building community is not. That's not to say it doesn't have value, but I can't put it in the list. The Emotionalism logo is a highly creative work. Here's a huge problem. We're using the entire work. By reproducing that logo and creating a sticker from the whole album cover, we are using a large portion, or in this case, the whole work, not a small portion of it. And Fair Use Doctrine was designed to allow people to use portions of copyrighted work for specific purposes, not to infringe upon the copyright holder's right to reproduce their own work. Okay, what if I want to turn it into a cross stitch? I'm just going to do one, and I'm going to sell it on Etsy. I'm going to make like $1 because I don't think you make much money on Etsy. Okay, now we have a condition favoring fair use that we didn't have before, and that is a transformative use. Just making a copy and slapping on a sticker, that's not really transformative. Taking the time to figure out how to translate that image to cross stitch, there's creative, transformative, effort that goes into that process, right? So that condition would be favoring fair use. But on the flip side, now I'm going to sell it. Now it's commercial activity, and I'm going to profit from the use, that whole dollar, right? So that's going to undermine fair use. And we still have the other problems. It's for entertainment. It was highly creative work in the first place. The entire work is being used, and it was widely distributed by the copyright holder in the first place. What if I want to make a sticker and use the lyrics, decide what to be and go be it, and I'm going to combine that with a photograph or some little drawing that I made, some sort of, which I can't, but some sort of art, right? So I'm combining it. That's super important because that gives us, again, that first condition favoring fair use, that's a transformative or productive use. If I just have a sticker and it just says decide what to be and go be it, and that's it, it's black letters on a white background, nothing fancy, Times New Roman font, then I don't get to have transformative or productive use, and that's going to be more problematic. Again, it's published work. Now, instead of taking the whole album cover, I'm just taking one line from a song. Not using the whole work, I'm just using a small quantity of work. Yes, those words are central to or the heart of the work, but I think that's really offset by the very small quantity of lyrics. It would be easy to see how the Avetts might want to sell stickers with the emotionalism logo on them. They have in the past. They may again, right? And by giving away stickers for free, I could be potentially undermining the market for their own use of their artwork. But by creating a sticker that says decide what to be and go be it and combining it with my own original artwork, they may offer a sticker for sale that says decide what to be and go be it, and have those work, and have their own artwork on it, or not. But now we've still got two different products, right? Because I've only used a small portion of the work and I've transformed it. So this one is a lot better than the example where we're using the entire album cover. And that's really because we're using a small portion of work and we're transforming it. Okay, so summary. Is it protected by copyright? This question comes up a lot in the Facebook comments and posts. Is it protected by copyright? You just have to ask yourself, is it original creative work fixed in a tangible medium of expression? In other words, is it music? Is it art? Is it photography? Is it any of those things super broadly? Then the answer is yes. We're dealing with copyright law. And unless it's protected, unless it has a Creative Commons license and the creator has put it under a Creative Commons license, which again would not include the band or any of the artists making posters, we're only talking about fellow fans taking photographs, etc. Unless it's under Creative Commons, it is protected by copyright law, and then the only way that you can use any portion of that work is if you feel good under fair use. Here are some general guidelines, sort of summarizing everything we just went over with fair use. This is not legal advice. I am not your lawyer. This is not legal advice, but these are general guidelines. It is probably going to be fair use if you use a small portion of the protected work. So you use a line or two of lyrics, use an element of artwork, and you combine it or transform it through your own creative work, and you use it for personal use or you give it away to a small group of people for free. And all three of those have to be true. Small portion, combine or transform, personal use, or give it away to a small group of people for free. If you ask for money to offset costs, if you use a small portion of protected works and you sell it on Etsy, or you don't combine it through your own creative work, and you're selling it on Etsy, that's probably not going to be fair use. It is probably not fair use if you use the entire protected work, use the whole album cover, use a poster, you use lyrics, or a photograph that someone else took. Or you simply reproduce a protected work in whole or in part, right? It's different to simply reproduce than it is to use. I could take the entire work and incorporate that into something larger that I'm doing, as opposed to standalone reproduce, right? Those are two different things. Neither of them are fair use. I still can't do that. Or give it away to a large group of people, even for free, or offer it for sale. Probably not going to be fair use. Okay, so here's a final exam. I made this image below using a photograph of the teardrop backdrop, and then I manipulated the colors and wrote the word "say love," trying to mimic Scott's handwriting. Is this fair use? Rather than sit here and have empty video while you try and figure out the answer, I encourage you to pause the video. You can go back and look at the factors and try and figure it out on your own, because in just a second, I'm going to fast forward to the next slide, which will have the answer. Fair warning. 3, 2, 1. Oh, this was totally a trick question because I did not tell you how I intended to use it. That matters a lot, okay? That matters a lot. I just went through all the things with fair use general guidelines. Am I selling it? Am I giving it away to a large group of people? Is it for personal use? Am I giving it away to a small group of people? That is going to matter a lot. But here's the real reason I wanted to show you this particular image is because it, like many of the things that folks are doing, which are really cool and creative, it uses at least 3 elements that are potentially protected by copyright law. And the bottom line is you have to look at each element that you use separately, right? Scott's handwriting style, potentially protected, the teardrop backdrop, and the words "say love." Well, handwriting style, I went and looked. I don't think it is actually protected by copyright. Those aren't actually his letters. I wrote them myself on Photoshop, or I think Photoshop, mimicking his handwriting. Handwriting style probably isn't going to be protected by copyright. So I'm probably okay there. I could try and forge things in something that pretends to look like Scott's handwriting all day long, and that's not going to be a copyright problem. But that teardrop backdrop, absolutely protected by copyright, right? It was published. It was published when it was projected on the screen behind them as they performed. But I transformed it. I manipulated colors. I changed the size of it. I used it as the background for letters. Is that going to be enough? Again, it's a lot. It's going to go back to how I use it, right? And then the words "say love," small portion of a song, but they're the heart of the song. That's probably going to be okay. I feel pretty comfortable with this image as long as I'm going to use it for non-commercial limited use. That's the bottom line. One last thing. I think once you've kind of thought about these sort of fair use questions and the general guidelines, etc., one thing that I think we should all keep in mind is we're in this community and we're interested in making things and sharing them with other people because we love the art, we love the music, and a way of sort of creating community. So I know that nobody wants to inadvertently undermine any of the artists and this is their creating this work and selling this work is their livelihood. And that's not just the band, that's also the poster artists. So I think the final questions you want to keep in mind, right, is are you creating something new or are you simply reproducing another person's work? And I would suggest to you that forget fair use. If you're creating something new, that's morally okay. And if you're simply reproducing another person's work, whether it's for free or not, that is not so clearly morally okay, right? It's their work. And if they want to reproduce it or not, that's up to them. It may be a compliment to them that you like their work so much that you want to reproduce it, but they are only going to remain hopefully not starving artists as long as they can sell artwork. And if we even are giving away for free their artwork, we are undermining and potentially competing with that artist. So I would just put that's not my area of expertise because that's morality, not law. But hopefully I've given you all something to think about and given you a little bit of guidance on the law. And if you have any questions, please let me know. Thanks.